Alrighty, so we're gonna go ahead and get started. I want to thank you all so much for joining us tonight for our renters and legal and housing basics workshop. On behalf of Build Up Justice NYC, we truly appreciate you taking the time to be here. We know that navigating housing issues can feel confusing and stressful, especially when you're unsure of your rights as a tenant. Tonight is about making sure you have clear information, understand the protections available to you under New York law, and just know where to turn if you need support. Our goal tonight is simple, and that is that you leave this workshop feeling more informed and more confident about your rights and better prepared to take the next step if you are facing a housing issue. For those who may be joining us for the first time, my name is Kendra Dunstan, and I'm the Development External Affairs Coordinator at Build Up Justice NYC. Formerly known as Brooklyn Legal Services Corporation A. We provide free community-centered civil legal services to low-income New Yorkers across all five boroughs. While we did change our name, our mission remains the same, and that's advancing economic and racial justice. Our work focuses on protecting stability and long-term security for tenants, homeowners, small business owners, and families. As you can see on the screen, our programs include preserving affordable housing, where we do our eviction defense, anti-harassment advocacy, and tenant protection work. Community and economic development, where we support small businesses and nonprofits. Consumer economic advocacy, and that includes foreclosure prevention, tax assistance, our new bills and estates planning, and financial stability services. And under that unit, we have a domestic violence services unit that assists survivors with orders of protection, custody matters, child support, and other legal needs. And tonight is part of our Preserving Affordable Housing Queens unit work, which focuses on helping tenants understand their rights and access legal support when they need it. We are especially grateful to New York State Assemblymember Lorinda Hooks, who is sponsoring tonight's event. Assemblymember Hooks represents District 35, serving communities including Corona, Lafayette City, East Elmhurst, and Regal Park. Throughout her career as a community organizer and advocate, she has been deeply committed to strengthening neighborhoods and expanding accesses to resources for working families. Her leadership has focused on improving quality of life through community engagement, economic opportunity, and equitable access to services. And we are thankful for our partnership and bringing important information like this directly to residents. I'm just checking the room to see if anyone from her office is on tonight. Uh, okay, well, she may be able to join a little later, but we'll just keep moving forward with her now. And now it's time, and my pleasure to introduce our presenters for this evening. We have Molly Kryn, our staff attorney with Build Up Justice NYC, and Molly represents tenants in both defensive and affirmative housing matters. Prior to joining Build Up Justice NYC, she served as a litigation fellow with Everytown for Gun Safety, a law clerk with the United States District Court for the Eastern District of New York, and a litigation fellow with the AARP Foundation. She's a graduate of the University of Michigan Law School and Bernard College. Also joining Molly is Al Della Bartolomea, a social worker on the Preserving Affordable Housing Queens team. Al brings extensive experience supporting community members through housing and social services. Prior to joining Build Up Justice NYC, Al worked as a coordinator for community engagement and volunteer services at Union Settlement Association in East Harlem and as a senior housing specialist at Downtown Goddard. Al has also supported community land trust development in New York City and has worked on the reentry and prison abolition programming with the Center for Community Alternatives. Al holds a BA in Urban Studies from Queens College, right in Queens. And then before we begin, I just want to acknowledge Tiffany Fimiano, the program director who oversees this work. Tiffany is an experienced housing attorney who has represented hundreds of tenants across New York City and brings years of litigation and eviction defense experience to this work. We are grateful for her leadership and for supporting tonight's presenters. And we are very grateful to have all of them here tonight to walk us through these important tenant protections. Right before jumping in, I just want to let you know that we will have a Q&A at the end of the session. And you can either type your questions in the chat or you can use the little hand raise feature on the bottom of your screen where we will be able to unmute you and you can ask the experts directly. Again, we do have Antonia Reyes on the call, who is our language interpreter, and she will be able to translate anyone who feels more comfortable speaking in Spanish tonight. So, with that, Molly and Al will guide us through rent regulations, including how tenants can determine whether their apartment may be rent stabilized and what that means for their rights. They also cover what to do if you're experiencing issues in your apartment, such as no heat, no hot water, or other serious repair problems, and then eviction and housing court basics and resources. And they'll talk about what this process looks like and just some steps that you can take to really empower yourselves. So, with that, I will now turn it over to Molly and I.
Thank you so much, Kendra. I really appreciate it. What a beautiful, warm introduction. I just wanted to, note for everyone that to the extent you like this PowerPoint, I just want to give a shout out to Kendra because I could not have done it on my own whatsoever, not even an inkling. Thank you, Kendra. And I also want to thank you all for being here tonight. I have, this is precious time. This is your Wednesday evening, and you're choosing to spend it with us to talk about housing related issues, which tells me this is something that's serious to you. This is maybe something that's concerning to you. And I want to thank you for your time and your trust in us. I'm really hopeful that we can provide you with helpful information on these topics. And I want to give a caveat about that. What we're going to go over today, we could probably spend many sessions, many hours doing. And instead,
Oh, I'm sorry, Molly. I just need to interrupt you one moment. I do see Fernando Meza on the line, and he's from Assemblymember Hook's office.
oh,
So sorry to interrupt you. Hi, Fernando. Thank you so much for joining us tonight. And thank you to the Assembly member for sponsoring tonight's event. You know how much Assembly Member Hooks has dedicated her career to uplifting our community and advocating for policies that improve the lives of all working families and everyone out in District 35. I would like to turn the mic over to you for a few moments if you'd like to speak on behalf of Assembly Member Hooks.
Hey everyone, my name is Fernando Meza. Thank you for that warm introduction, Kendra, and thank you so much for bringing the people together so we could go over these much needed resources and these much needed information to the community. And I'm really happy to see a really great turnout. I'm hoping the member could swing by maybe just to say a couple few words. I know right now she's it's late at night and she still has meetings going on late into the evening. We're currently, still negotiating budget. And so hopefully I could try to sneak her away from the negotiations and get her
Mhm.
on this. But again, thank you, Kendra, and thank you to Build Up Justice for hosting this really important webinar. And I know we have some more webinars coming up. So
Mhm.
yeah, that's all I got. And yeah, greetings from AD35. I hope some folks here are from AD35. If you guys aren't, definitely swing by to check out the cool stuff in our assembly district.
Absolutely. Thank you so much, Fernando. Yes, I know how busy you are because actually the Assembly member is sponsoring two events tonight for us, one our tax series and then this housing workshop. So, and I know they're up in Albany running around. So thank you so much for making time to say hello and stopping by. And we look forward to your continued partnership and working on more programming that we can bring to the community. All righty. Molly, it's so sorry to interrupt you again, but now the floor is yours.
absolutely no apology necessary. All I was going to say was, I'm hopeful that we can provide you with some helpful information on these topics. But we could spend hours talking about these things. And so I wanted to flag that we'll sort of be going over the basics. But I encourage everyone, if you have concerns, you might have special circumstances, there might be unique exceptions to these issues that we're talking about that impact you. If you do have an issue, I encourage you to reach out for further support so that it can be more tailored to your needs. So I think first we'll talk about rent stabilization. So rent stabilization is a great thing for tenants. It means for you stronger protection, stronger tenants' rights as compared to unregulated market rate units. So some of those protections involve there can be limited reasons for eviction proceedings to be brought against you, those are limited by statute. Some of those reasons include like non-payment of rent, maybe there's a nuisance going on, or a violation of a term of the lease. You're also entitled to get lease renewals when you're a rent stabilized tenant, but there are a few exceptions when you can lose that entitlement. It might involve like the owner needs to take over the home for their own personal use, or you're not meeting it's alleged you're not meeting the primary residence requirement. With primary residence, you need to be treating the rent stabilized unit as your primary permanent home, so living there full time for a majority of the time. But with those benefits, I want to point out that there can also be succession rights, which means that when you're the tenant of record, or you have a tenant of record and the tenant of record passes away, a family member might be able to take over if that family member has lived there for at least 2 years with you, or if they're a senior citizen, or maybe they have a disability, only just 1 year, which is a pretty incredible right. In addition, unlike unregulated market rate units, there are regulated rent increases. Specifically, the mayor appoints a rent guidelines board, and every year the rent guidelines board needs to vote on increases to 1 and 2 year rent stabilized leases. And that's the only way your rent can be increased annually, is through the rent guidelines board to some extent. But even if you there are ways even for rent stabilized tenants to avoid those rent guidelines board increases if they apply for something called SCREE or DREE. SCREE helps senior citizens freeze their rent so that it doesn't keep increasing year over year with those rent guideline boards increases, and DREE protects disabled tenants in the same way to avoid those year over year increases. And I want to point out, we could probably spend more time talking about this. You might see another reason for increases, which is called MCIs or IAIs. That has to do when there are building-wide or individual unit improvements. And the law says that the landlord can charge a small percentage of those improvements to the individual tenant. And those are also really regulated. So if you see those letters, on a rent bill or something, you're like, what is that? I just wanted to point out that's something you might see. That's sort of the beauty of rent stabilization, is that these things are highly regulated. And so you can get some protections there. If you are interested in, if you're like, hey, I am a rent stabilized unit, I really want SCREE or DREE, you're really going to want to reach out to the State Division of Homes and Community Renewal, DHCR. For all rent stabilized tenants, I feel like make DHCR your best friend. They have tons of information for you, but they can also assist in getting these rent freezes, and they house the application for SCREE and DREE. You might be wondering, I don't know if I'm rent stabilized. How would I know whether or not I am rent stabilized? There are a few ways you can find out. You can look at your lease. It should say at the top of the lease whether or not you're rent stabilized, or there should be attached to your lease a rider that says that it's providing the rights for rent stabilized tenants. You also can sort of see often in rent stabilized leases the math that's being done to add that rent guidelines board increase to your previous year's rent to calculate the new rent. And so that's also a clear sign that you're a rent stabilized tenant. Let's say you don't have a physical copy of your lease, or it's difficult to find one, or you're unsure if you can trust your lease. Other ways you can find out is searching online. These are 2 websites that give you some kind of estimate. It's called Am I Rent Stabilized? Very helpful name. And Who Owns What? These can only really provide you an estimate, because rent stabilization and regulatory status can actually vary from unit to unit within a building. So these will just say building wide, maybe how many units. And this is going off public records that they can find. Some of those might be outdated or incorrect. So I really encourage you just to treat these as an estimate or a guidepost, but not as a final word. If you're looking for that final word, I strongly encourage reaching out to HCR. That's the Division of Housing and Community Renewal. You can go on their website, the link is there, and you'll be able to fill out a form that asks, am I rent stabilized? Or how can I get the rent history for my unit? One of the beautiful things about rent stabilization is that landlords are required to register the rent. So you can look back like even to the 80s and figure out the rent in your unit year over year since the 80s, and when there's been increases and why there's been increases. It's a really beautiful public resource to have to equip you with more information. The other caveat to provide with all this information is that this will tell you whether or not you're being treated as rent stabilized. Something we encounter as tenants attorneys is that there are times a landlord might claim that you've been deregulated, but for some reason, either the steps haven't been followed or the proper process hasn't been followed, and really you should continue to be treated like you're rent stabilized. That's another situation, sort of like I flagged at the beginning. If you have any inkling that you should be treated as rent stabilized, but you're not, I encourage you to reach out to an attorney to sort of dig in deeper, because that is a more nuanced thing that we can really get into today in this format. On the next page, I can actually show you an example of what who owns what looks like. It's a really powerful public resource to give you information. You type in an address. This is actually an address in LaFrac City, and it can tell you information like when was the year that it was built, how many units there are, what the change in rent stabilized units has been. You can see in this example, there's been a drop. You can see whether or not there's been eviction files. You can see what's the name of the landlord. You can see, if you hit that portfolio tab on this website, you can see other buildings that are owned by this landlord. It's a really powerful tool to learn more information about your building. And again, these give you estimates. And on the right-hand side, it also provides useful links that continue to give you more information about your property. I also want to flag, they'll tell you things like open violations or total violations. What that means is those are HPD, Housing Preservation and Development violations that have been placed on your actual building and that remain open or unresolved by your building's owner. And that sort of leads to talking more about conditions issues that I know are plaguing a lot of people, that they're not getting the safe living conditions that they're entitled to under the law. And then we have some talk about there, something called the warranty of habitability. And the warranty of habitability is your right to have safe, healthy, livable housing. The warranty of habitability is the landlord's obligation, and this applies to all types of buildings. The landlord must keep the building in safe and habitable condition. You have a right to ask your landlord for repairs. It's right there. It says it cannot be waived. Even if you don't see anything about it in your lease, you are still entitled to this. Let's say your landlord says, look, I'm going to shave off $50 of the rent, but I'm never going to touch the repairs. This is all on you coming out of your pocket. That goes against this warranty of habitability. You cannot waive this right. Certain conditions will definitely threaten your life, health, and safety if you don't receive them. In particular, no heat, no hot water. That's very serious. And, you know, those go to the heart of what this is meant to protect. A few things about that. If you're not getting those conditions, you know, one, the warranty of habitability, while it's your right and entitlement now, something we're going to get into talking about is eviction. These can also form the basis of a defense when you're actually in housing court. It's very important to make note of that now. But also, if you are a rent stabilized tenant, which we talked about, things like heat or hot water are essential services that you need to be receiving from your landlord. If you're not receiving essential services from your landlord, but you're a rent stabilized tenant, again, I want to encourage reaching out possibly to the Division of Housing and Community Renewal. You can file a complaint saying I'm rent stabilized and I'm not receiving the services I'm meant to be receiving, those essential services like heat and hot water. The next thing is generally the landlord will pay for repairs. If the landlord alleges that you've caused the condition that needs repairing, they might try and seek it from you. I want to flag, though, that generally it is the landlord's obligation to provide these repairs. And so what that means, though, is that you have to give them an opportunity to make the repairs by giving them notice of the conditions that are plaguing you in the unit. You should also give them an opportunity to do the repair. So sometimes people, for good reason, want to do these repairs themselves, but really it is the landlord's obligation to do them, and they should be the ones doing them. If you've continued to try to advocate your landlord to do something like changing a light bulb or fixing a lock, and you are left with no other option but to do it yourself, I again would encourage that to be a last resort because it really should be the landlord's responsibility. You should be sure to keep note of your expenses related to that and seek reimbursement from the landlord. And ultimately, this can be the basis, if you are in housing court, of a defense saying that you need a reimbursement for necessary repairs that your landlord forced you to do themselves. But again, this is something that really should come from the landlord themselves and really need to be giving them notice in the first instance. I want to also mention utilities. People often have a lot of question about utilities and who pays for what. That one, you really want to look carefully at your lease to figure out who is supposed to be paying for the gas, the heat, the electric, and the water. It should be clear from your lease. If your lease says something that is not what you're experiencing, you might want to look into that further, right? If it's an essential service like we're talking about and you're rent stabilized, you could go to the Division of Community Housing and Renewals, Division of Housing, Community and Renewals, and create one of those complaints that we've talked about. But additionally, I want to flag something that people might know about on this call is that there was this big settlement recently with a landlord in the LaFrac City related to overcharges and water bills. If you think that that impacted you or you think there might be a similar issue that's plaguing you, that was an investigation that was run by the State Tenant Protection Unit. And I do encourage you to reach out, or if you have questions and you need to get in touch with them, we can help put you in contact. Should that be kind of raising an alarm bell now that we're talking about it today? Additionally, sort of a partner of warranty of habitability is the issue of harassment. I think, a lot of times when we think about harassment, we think about abusive language or derogatory language. But I want to flag that the New York City Housing Maintenance Code actually defines harassment like pretty expansively. It can include cutting off or disruption of your services. So that lack in heat of hot water is not just an issue with your warranty of habitability. It can rise to the level of harassment. The key here is whether it's like any action that would make you want to leave the unit or give up your rights to the unit, give up your rights to safeguard your unit. It can involve failure to correct hazardous conditions or failure to provide necessary repairs. It can be things that we might be more familiar with, like threats, intimidation, or violence. It can also be repeated unwanted buyout offers. So if your landlord is constantly calling you, trying to make offers to get you to give up your rights when you've asked them not to, or they do it in a way that's not required by law, there are certain steps they have to take and certain ways in which they have to make those requests, that can also constitute harassment. And again, this is a protection that is for all tenants. No one should be forced to endure harassment as a tenant. And I want to talk a little bit about the tools that are available to you should you find yourself facing this breach of the warranty of habitability that we've talked about or facing harassment. As I've mentioned before, the number one thing you want to do is notify the landlord. They have to know what's going on inside the unit and be put on notice about it. Even better if you can put it in writing that you provided notice, like an email, you sent them a letter. Keep a copy of the letter if you send them a letter saying these are the issues and I need them to be addressed. You can, if you've had to make emergency repairs as well, document it. Tell them, I asked you this many times to come. You did not come. I had no other option but to do it myself, and this is what it cost me. Things like that. You want to get these notices in writing to your landlord. The second thing you can do is take photos of it. So if you have a condition like there's mold in your bathroom and it's getting worse, I encourage you, take pictures, not just once, but multiple times. If the landlord does come out to make repairs, but things are not repaired, take pictures right after to show that the repairs are not getting done. This could be relevant later on, which I'll get to. The other thing I want to mention is if you're dealing with heat issues, it could also be useful to take a heat log. Today it's 9 a.m. and outside the temperature is 24 and inside my apartment it's only 59 degrees. Today it's that kind of a thing, to build a pattern to show that you are enduring these lasting unacceptable conditions. The other thing you can do is call 311. 311 is a great resource to lodge your complaints related to the conditions in your unit and to get the city involved in making necessary repairs. I want to flag that there are landlords that when you call 311 will retaliate against you, but there are protections for tenants against retaliation. It's just something to be aware of. I don't say this to scare anyone off, but just an unfortunate truth that sometimes landlords may try to retaliate against you, but there can be protections. I encourage you, if you're feeling at risk or concerned, again, reach out for guidance specific to your unique situation if you do have those types of concerns. But what happens when you call 311 is you can even search your building on something called HPD Online. They'll usually log your complaint on something called HPD Online. Then they'll send an inspector out usually to figure out, does this rise to a violation of the Housing Maintenance Code? Maybe it doesn't, but maybe it does. And that'll start a clock to require your landlord to make repairs within a certain amount of time or face civil penalties for it. The next step, if it requires further escalation, could be filing an HP proceeding, which is when you go to housing court and actually initiate a case against your landlord that requires them or demands that they make these necessary repairs. It can also be that the HP proceeding can even be used to force your landlord to cease any harassing behavior as well. That is, starting a lawsuit against your landlord. So I want to flag, when you go to housing court to start a housing case, sometimes there are filing fees. And if you're like, but I can't handle filing fees, there are waivers for that. So I hope that won't feel like a barrier to anyone, that you can say, I don't have the money to pay these fees, and they will give you a form to waive them. The other thing I want to flag about starting an HP proceeding is that this is a formal lawsuit. So you will be required, a very important step when you're starting a lawsuit is serving papers on another party. We can talk about service if there are further questions about service in a Q&A, because it's rather technical, but the most important thing to know is that it's something you got to do and that you're going to be asked to file an affirmation service about it. Otherwise, your case could be dismissed against you for something like not mailing a letter you were supposed to mail. So I want to flag there can be a lot of technicalities around this, and it is important to pay attention to they'll give you instructions if you're going to go file an HP proceeding on service. And so I want that to be top of mind for people when they're starting these proceedings. I think then we can talk about, these are sort of the tools that you equip. This sort of, it describes a little bit more about the HP proceeding, but now it's sort of, when are you in housing court? When it's not by choice maybe, and that's when you're facing an eviction. And I want to talk a little bit about evictions. All good, all good. Before we get further into like what is an eviction, I want to sort of explain that there are two reasons usually why eviction proceedings can be brought against you. There's something called a non-payment proceeding, and there's something called a holdover proceeding. We could go to the next slide, please. The non-payment proceeding is when the landlord is claiming that you owe rent. So they're saying, you haven't paid like rent in X amount of months, and for that reason, we're seeking to evict you. A holdover proceeding is where the landlord says, you don't have permission anymore to be here, and that's why I'm seeking to evict you. So there, it has nothing to do with whether or not you owe money. You might have been on time every single month, but still for some reason, the landlord's claiming you don't have permission to be there. There are ways to stop these proceedings, and I'm going to talk about that a little further. I want to talk about what is an eviction to sort of demystify something that I think often comes up, which is people fear that their landlord can just change the locks on them. It is absolutely illegal. All evictions must go through the court system. The landlord cannot just change the locks or put out your stuff on the curb without going formally through the court system. If that happens to you, a landlord has changed your locks, I encourage you to either file a police report, or you can even walk right to housing court and file one of those HP proceedings against your landlord to be restored to possession. Because again, all evictions have to go through the housing court. It's a very formal process. These are sort of the technical terms that are associated with it. What happens is, let's say there's something like a judgment of possession where the court has said your landlord is now entitled to possess the property you were previously possessing. They'll then sign something that gives uh, permission to evict you. It's called a warrant of eviction. The landlord then takes that warrant. They can get a city marshal, because the marshals are the ones that actually effectuate the eviction, and say, here's what gives me permission to evict this person. The marshal will then file a notice of eviction on your door often that says, within 2 weeks, you must be out or we will evict you. The reason I really like to break this part down of the technical process of eviction is that eviction is not being asked to leave, right? Eviction is not being told you're being evicted. It's not changing the locks. It's not getting a letter in the mail. It is a very formal process. So you have time, that means, right? A lot of times we think sort of worst case scenario right away, but there are times to sometimes remedy the situation. I want to talk about that a little bit in the next slide. The first step of an eviction is called a predicate notice. And in those predicate notices, it'll tell you what you need to do to avoid an eviction proceeding. With a non-payment, that's called a rent demand. And it usually says within 2 weeks, you must pay X amount or I'm going to start an action against you. If you pay that amount, they will not then start the action against you. With a holdover, it can be a little bit more complicated. There are multiple grounds for a possible holdover. It could be something like you no longer are on a valid lease. You are using this property illegally, or you are breaching a term of your lease, or maybe it's happening in such a way that can be cured. So these are called a notice to terminate, a notice to quit, or a notice to cure. And it kind of varies depending on the basis. So and the amount of notice you get varies depending on which basis your landlord is invoking. So it's hard to give a general rule here, but usually what these notices will say is like, you must do X or you will be brought to an eviction proceeding. So let's say you're violating your lease because you have a dog and you weren't allowed to. A notice might say like, this is a notice to cure. You have a week to get rid of the dog or we're going to start an eviction proceeding. There might be something like a notice to terminate that says, we need you out in 60 days or you're going to have an eviction proceeding. But if you do move out, you can avoid an eviction proceeding. But again, there are often ways through the court system, if you have defenses or whatever. I'm not encouraging anyone to leave sooner than they have to. I'm just explaining sort of that this is a step at which you can avoid court involvement. But the next step is getting court papers, formal court papers. In either the non-payment or the holdover, it starts with getting something called a petition, which is the statement of facts against you. It says something like, I am the landlord. This is the reason why I'm seeking to evict, and it has some supporting information. It's accompanied by a notice of petition. And usually it's that notice of petition that's going to give you that next court date. And so it's very important to look at that. You want to look at both very carefully to tell you what your rights are, what to expect, what is being alleged against you. You want to read them carefully for any inaccuracies or anything like that. But particularly with the notice of petition, you want to look carefully to tell you when you have to be in court next and how you can answer the claims that are being alleged against you. And in some instances, like the next step again is going to court, answering the petition, but in some it goes straight to IP intake. It kind of depends on whether or not it's a non-pay or a holdover. And so what's happening right now is IP virtual intake is happening in all of Queens Housing Court, meaning you're going to be given, you might be familiar that there's this amazing thing in New York City called right to counsel. That's not a guarantee to counsel for those in housing court, but it is a system by which they're trying to funnel as many tenants as possible to legal services like ours and others to try and connect tenants to attorneys. All that happens is usually the first step is getting a date that's called the virtual IP intake. You don't have to, you can go to court or you can appear virtually. You have to have with you your index number and your contact information. What happens is you'll either join like a Microsoft Teams meeting or you'll call in and they'll go down the list. They'll say your index number, your name, you'll give your contact information. That's it. It's a very informal sort of, it's not the same as going in front of a judge, right? You're talking to a court employee. The next thing is that you'll be screened for eligibility. The court employee will collect that information. They'll give it to the Office of Civil Justice. The Office of Civil Justice will call you back to figure out if you're income qualified to be referred to a legal services organization. If so, they'll give you that information to a bunch of different providers. And that legal services organization will usually try and contact you to do their own intake, to figure out if they have capacity to take you, if they're not conflicted out from taking you, if you meet their eligibility criteria, all of that stuff. A lot of times they'll try and meet with you before your next court date, but sometimes they'll be there waiting for you at that court date. And the reason I say that is because you don't ever want to miss a court date, right? You can, if you do miss a court opportunity, you can default and lose your opportunity to defend yourself against the allegations you're facing. But what I want to stress here is that, you might think, but I'm supposed to get an attorney. No one called me. They're going to handle it. No, it's really important that you show up for all your court appearances. And even if you didn't connect with your attorney or anything, you don't want to lose that opportunity. And so it's really important that you're paying attention and being diligent about those court appearances, even if you haven't heard from an attorney in advance of that court appearance. And yeah, because you wouldn't want to lose that opportunity to defend yourself. And again, we can take more questions about this process, but I do want to kick it over to Al to talk about some of the benefits and resources that you might be able to avail yourself of.
Thank you, Molly. Very well stated, all of that. A lot of information for everyone to take in. So like she said, please, at the end of this, give us questions, reach out to us. I'm going to go into some public resources and benefits. And similar to Molly, I'm going to be doing broader strokes about everything because this is stuff that also can get very nitty-gritty. There's a lot of exceptions to cases and stuff like that. So personal cases, anything, send questions. But in general, what is public assistance, right? What are we referring to when we say public assistance? And that's a system of social welfare networks that are put in place to help people meet their daily needs, okay? So in this context, we're going to be talking about things like cash assistance, SNAP benefits, HEAP, shelter allowance, and all of these are needs-based programming, okay? So needs-based means that unlike the topics Molly just covered, these are not things you're necessarily entitled to. So this is needs-based. That means it's based off your income, your household size, disability status, citizenship status, couple age, varying factors, if you have children. So cash assistance, that's something I think most people are familiar with. Some of these might look familiar. You might have an active case or pending applications. Cash assistance is funds directly distributed to you via EBT, electronic benefits transfer card. And it's again based on your income. You get a monthly amount and it's used to supplement your income so you can meet your basic needs. With that, there's SNAP benefits, right? Supplemental Nutrition Assistance Programs. Some people still call them food stamps, but they haven't been physical stamps in a very long time. Also gets put on your EBT card. And you can use that to buy food and nutrition type products. And then there's HEAP, Heat Energy Assistance Program, and shelter allowance. These two, unlike cash and SNAP benefits, do not get distributed to you directly. These are benefits that would go directly to your utility provider usually, or to your landlord. So if you're getting shelter allowance, that's money towards your rent, again, based off your income, based off your household. And if you're getting HEAP, that's money going towards your utilities. And would go usually directly to your utility provider. All of these resources are found on the Access HRA app or web portal. And that's where you can check things ongoing. Oh, you could go, yeah, thanks, Kendra. I'm not and that's where you apply. But I want to talk a little bit before we leave this slide about HEAP. A thing to note, as Molly was saying, this is a time of year, the winter, right? Heat energy is something that people have a lot of concerns on. Utility bills get high, all of that. We're about to be going into the summer. And it's important to note that HEAP has programs in place to help with cooling and heating. So on April 15th or 14th, I believe, 15th, you're going to be able to apply for assistance to install an AC and to help pay your cooling bill ongoing. So everything is going to get circulated at the end of this presentation, but I really want you to take note if you might be in need of that, because even if you don't have an active cash assistance case or public assistance case, some of those programs you can apply for one-off assistance. Because again, like I said, it's based on something called standard of need. So I'm going to kind of touch on that because I think a lot of folks are familiar with these general public assistance programs. But standard of need is based on a couple criteria. Okay, so It's based off, like I said, things like your household size. And when we say household size, sometimes that confuses people because you think, okay, who's included in my household? What does my household look like? You can have multiple public assistance cases within the same household so long as you're people with separate finances. Okay, so your household could be you and a roommate, that would be separate households. But if you're people who are legally bound, so you have a domestic partnership, you're legally married, or you're someone with children, or if you were two adults living in a household with shared children, you are all considered one household. But let's say you're an intergenerational household, everyone supplies for their own financial needs. Everyone has a job or is working or somehow is supplementing their own financial needs. Everybody in that household, as long as they're adults, can have separate cases, right? So we employ you to, after this session, kind of reconsider maybe who's your household. Are you all getting the benefits you could potentially be eligible for, right? Is everyone in your household taking advantage of these resources? Because living in New York is expensive. And if there's a means to have some of that cost offset because it is very expensive, right? It's important that you take advantage of what's available to you. So like I said, there's household composition and household income. And some of these things are calculated. It gets a little tricky, but it's all based off something called the federal poverty level, which you could look up. And it goes by the number of people in your household and your monthly income. So, for example, if you're wondering currently, why am I not eligible for cash assistance? Perhaps you're just one person. You would have to make $1,729 or less per month to qualify, right? So there are these really hard set income standards that you could potentially offset with things like childcare costs or extensive medical needs. Like as an example, if you have diabetes or something like that and your insulin isn't covered, and that's a really high medical cost that you can't ignore. You need that to get by. HRA and these qualifying agencies could deduct that from your income. So there are some exceptions, some nuance and things. Again, if you have questions about why you maybe not be eligible, you think, or a family member, if you've had conflict with an application in the past, please reach out to us because there is a lot that goes into it. And also, I'd like to note that mixed status households, so households that have people who have citizenship and non-citizenship, are allowed to apply together. It's just that non-citizen in your family may not count towards your household size, but you guys could still obtain benefits as a family. And I guess moving forward, with public assistance, there's those programs, and then there's also common housing subsidies that again are needs-based subsidies. So all of the things I'm talking about are needs-based. They're all income-based. For these programs that I'm about to mention, FEPS and City FEPS, they both have different income standards. So FEPS is relying on having an active cash assistance case, okay? And you have to have an active cash assistance case and a child under the age of 18 because FEPS is meant for families to prevent eviction. So if you are in housing court and you're facing eviction and you have an active cash assistance case, you could reach out to HRA through your Access HRA app and your active case already, or you could go to a benefit access center or speak to potentially your attorney or the HRA in the courthouse. And we'll get to some more resources later on about benefit access centers and how those work. And you can apply to have your rent paid ongoing as long until your child ages out of the program and you remain income eligible. And also, FEPS can be used to pay your rental arrears. So to help prevent eviction by paying your rental arrears. And in addition to that, there's also FEPS to move. So you have an eviction pending and you don't have the funds to move. There's FEPS that could be put in place to pay your rent ongoing and help you move. So contrary to FEPS, which requires a child and a cash assistance case, City FEPS is opened up to a wider group of people because the income band is much higher, or the income limit. You have to be 200% or below the federal poverty line. So for context, for one person, that's about $2,600 a month. And for a household of two, that's about $3,600 a month. So that's kind of for a gauge where the income threshold is for City FEPS. So you have to meet that income threshold and then have additional qualifying factors, right? So you can be someone who served in the U.S. Armed Forces, isn't at risk of eviction. You can be currently receiving Pathway Home benefits and eligible if you're in a shelter already, or if you were referred by a City FEPS qualifying program and DSS determines that City FEPS is the only thing that will keep you from shelter. With that, if you're actively in court and you meet this 200% of the poverty line criteria, right? You have to have that active court case facing eviction, meeting 200% of the poverty line, and as well, either have prior shelter history, have an APS case, right, an Adult Protective Services case, or be in a designated community guardianship program, or if you're in a rent-controlled apartment, they will give you city FEPS in order to stay in that apartment and maintain it ongoing. So you'll get city FEPS ongoing. With that, contrary to FEPS, right, which you can have for a very long time, you can have it from a child who's 0 to 18. So you could potentially have FEPS for 18 years, right? City FEPS, you only are guaranteed 4 annual renewals. So that means you get your first year, at the end of the first year, you renew. And then every year thereafter, when you renew, your eligibility is reconsidered. So as long as you remain income qualified or you meet one of these other criteria that I've briefly mentioned, you can continue to renew. And at the 5 year mark, if you still are facing hardship or you can't pay your rent on your own, you can be reconsidered to extend it past that 5 year point. But it's common that you start to pay a larger portion of rent. So it's typically like 30% of your income. But at the 5 year mark, that's when you could either lose or be extended with this kind of change to the voucher. Um, and that's those two programs. Kendra, you go to the next slide. And then we're going to touch very quickly on Section 8 because unfortunately, a lot of people talk about Section 8 because it's been around for a long time, or you know a lot of people who are on it and it's very stable. But Section 8 has not been open for applications in a very long time. In June of 2024, they had opened the wait list, which they had not done in, as you can see here, over 15 years. So if you hear someone right now who is talking about maybe they're in the process of getting Section 8 or something like that, it's likely it's because they came off the wait list. But there are no new application portals that are open. There's no way for you to apply, no way to get on the wait list. So really what you're looking at here is something like City FEPS or FEPS if you're eligible, and then programs like the re-rental listings or the Housing Connect lottery, and then if you can find a rent stabilized or rent controlled apartment in the open market. But Section 8 is not really something that I refer people to because there's no means to access it anymore. But yeah, I thought we would put it here because some people still have them, so you can have a portable voucher or a project-based voucher. Your portable voucher means you can use it in different apartments, and the project-based voucher means that it's tied to the unit you're currently in. And then we're going to go into OSDs, a one-shot deal. This is something that is available to people across the board. So unlike everything I've already mentioned, which has these really set criteria, a one-shot deal is based on hardship alone. So your income plays a part here, but it is not a disqualifying factor. It's not the final say in whether or not you qualify. A one-shot deal is an emergency grant that's used to help pay rental arrears. It can also be used for things like utility arrears and some other extenuating circumstances, but in this context in housing, and most often, I think when people talk about it or just hear about it from other friends or family members, it's used for rental arrears. And the way a one-shot deal works is that you apply through the Access HRA app. And it's done a lot like a standard cash assistance application. If you already have a cash assistance case, you could do a shorter application. If you're on the website, it's on the right-hand side and it's called a special grant request. And it's a little bit shorter because HRA already has all of your information. But you qualify, or you could potentially qualify for a one-shot deal if you have rental arrears and you have a temporary crisis which caused them to accrue. And you can explain to HRA, hi, this is what I experienced. I maintain the ability to pay my rent ongoing. It's just that I have all of these arrears that have maybe gotten you in a court proceeding or you're about to be in a court proceeding. And if I don't pay these arrears, it could lead to me being evicted. And HRA will review your case. They're going to ask for a bunch of documentation. It's very important when doing a one-shot deal that you adhere to all of the documentation requests because that's the number one reason people are denied the first time around. Maybe you're missing something or they have an interview. If you miss your interview, that's another common reason that people end up getting denied. And HRA will pay a large amount of arrears in a lot of cases. We've had clients upwards of 20,000. So even if you think that maybe you have an amount that's too much, it's always worth applying because you do not know what they might offer you. You can contribute to the arrears and HRA will contribute. But it's also important to know that when you get a one-shot deal from HRA, it's considered a loan. So there's the possible of recoupment. Recoupment only happens In some cases, if you're on SSDI or you've received this grant through a cash assistance case for FEPS, for example, and children are involved, you typically don't have to do recoupment. And recoupment happens over a 12-month period. There's a maximum amount that HRA is allowed to charge you. And if you're still facing hardship and paying back that recoupment amount with your current expenses and bills is too much for you to maintain your current housing, you can advocate with HRA to have your recoupment reduced. So a lot of the time you end up paying back a significant amount less than what HRA has given you. But that's something to consider because you can't apply for a one-shot deal without agreeing to the repayment plan. It's part of the application process, and it's important for people to know that that money could eventually come back to you, and you might be required to pay it back to HRA. Um, and in troubleshooting, so all of these applications, there's troubleshooting. Um, there's document receipt, there's setting up appointments with HRA, doing things on the app. A lot of people don't have reliable access to internet. Maybe you only have a handheld device, you don't have a laptop. It's frustrating to do things just on your phone. I encourage you to go to your local benefit access center. All of them have scanners, so if you want to scan in your documents, that's a really surefire way to know that HRA has gotten them. It's important to keep good record when doing these applications, and going to the Benefit Access Center is a good way to confirm that everything that you have has been received. They're located in all of the boroughs, and it's based off your address, which one you would go closest to or which one you're assigned to. There's three in Queens, in Long Island City, Jamaica, and Far Rockaway. If you had previously a public assistance case associated with an old address, it's important you change your Access HRA information so that it's lined up with your current benefit access center or the closest one to you. Um, and yeah, I think that's everything for benefit for that. And then there's some city and state programs we've listed here. Kendra will go over again, but everything is going to get distributed. But I highly encourage though everyone visits their local library as well, because I send a lot of clients there for applications for help with different programs. They'll help you with a lot of computer stuff, applications, getting all that sorted. But take advantage of the resources closest to you. And yeah, that's it. Thank you everyone for sharing your evening with us. I'm also a resident of District 35, so I'm very happy to be with you all tonight.
Oh, amazing. You know, that's my hometown, District 35. So that's so awesome. Um, my mom is a district leader for 35. Then we have Lorinda Hook. So that is amazing that you are homegrown. And I want to thank you both for the information that you share with us tonight. We do have several questions in the chat, and I know we're getting close to time. So I'll go over a couple of minutes, and we're going to get through the questions in the chat. Deanna Neosi, I see you have your hand raised and you've been so patient. So I'm going to unmute you for you to ask your question live. Before that, if we do not get to all of your questions, um, as you can see, there's an email there, info@buj.org. Please email us your questions and we will get back to you. Additionally, like Al said, after this webinar, we will be sending you a link to this recording as well as all the links to everything that we talked about tonight, so you'll be able to access them. So with that, Deanna Neosi, you may ask your question.
Hello.
Hi.
Oh, hi. I was wondering, I'm living in the same apartment for about 28 years, and I've only had the lease signed for the first year. And my landlord had recently mentioned that she gets a letter every year from the DEP stating that we have lead pipes, and then I had the water tested and there's lead in my water. So I was just wondering like what I could do about this.
Sounds
Molly, we can't hear you. Sorry.
Can you hear me now? Any
Yes.
better? Okay, sorry about that. Great, thank you. Okay, it sounds like you might have some unique, you might need some tailored advice, but talking just like generalities, right? some things you can do if you're concerned about lead pipes. It might rise to the level of being so serious for your health that it's worth reaching out to 311 about. Have you tried? We can talk more. I won't go back and forth, but that might be something to consider. It also sounds like, though I'm not sure if I totally understood, that you're not getting lease renewals. And so you might have questions about how to get lease renewals, which could depend on whether or not you're rent stabilized or not rent stabilized. What advice there, right? Rent stabilized, like we talked about, you're entitled to be offered these lease renewals. There are laws in place that now specifically, like post 2019, that have to do with whether or not an unregulated tenant is entitled to lease renewals, or they can be not given for certain disclosed reasons, but it's supposed to be a reason disclosed to the tenant. So there might be more to get at there. So I hope that's just some like sort of general like issue spotting, some things that you might want to find out more tailored information about. But I would recommend, if something is as serious as like lettuce in your water, it might be worth calling 311 about if the landlord is not taking steps to mitigate.
Yes, and Dina, if you do have additional questions, because you may need more information, please email us at info@buj.org and we can answer some more specific.
Oh, thank you so much.
No, my pleasure. Thank you. Cynthia Wait in the chat. Thank you for being so patient. She asked, what if she has a rent-stabilized apartment and lived there more than 30 years? And she needs worn out floor tiles replaced, plaster done to the walls. Who is responsible for these kind of repairs?
Yeah, thank you, Cynthia. It sounds like, based on what you're telling me, it's not like normal wear and tear. It sounds like there's broken tiles, and maybe if there's broken plaster falling off the walls, that could rise to the level of like a housing code violation. And so I would reach out to the landlord first to do repairs. Like I said, the next step, try and get notification writing, try and get photos. And if it rises to it and feels comfortable to you, I would consider reaching out to 311 related to those violations or potential violations.
And so ultimately, the landlord would be the one who needs to rectify these issues as soon as possible.
Yeah.
Got it. Thank you. Minka, now I do see your question, but I see your hand is raised, so I will allow you to ask your question directly to our experts.
Hi.
Hi, Minka.
Hi. Sorry, there's like an echo about.
Yeah.
There's a few things. I take care of my brother who's disabled, and excuse me, so there's a few things. The door in the building, there's only a one way for him to get in, and they put in like two other doors, and he has a really hard time getting in because you have to go like that's the only place with a ramp. And I know before they sold the building, they were supposed to be putting in a ramp, like because the front of the building has stairs. Then the other side of the building, if you go on the other side, it's the same thing. That's where the laundromat is, but you have to come in and then go downstairs and then go up another flight of stairs. It's just really frustrating. And then when it just had the blizzard, I asked if I could park in the garage, like even though can't really afford it, but like just so that I wouldn't have to pull out the car to take him to his doctor's appointment. And the manager said no. Like he said, yes, there's spots available. It's $275 for the month. And I said, can I just pay for a month? And he was like, no, I can't do that. So then I tried plowing out my car, and then the trucks came and plowed the car back in. So, and I was wondering for myself if there's assistance for myself. I don't know if this is a really bad echo or not, but
It's a bad echo, but I think we're getting the gist of it. One is the wheelchair access for your brother.
yeah.
And should there be a ramp in front of the building? I think that's the first part of the question. And then the second part was about parking during bad weather. And if you are able to get maybe a month-to-month lease for your parking spot, is that what you're
Well, I
referring
just
to?
asked for during the storm because my brother has a special parking plaque that we got. He has the state handicap plaque tag, and then he has a plaque, but we didn't get the new plaque yet. But
Okay.
but those things don't really help in the bad weather, So that's why I was.
Molly, do you have any?
Yeah, I do have some thoughts if I can. I think, Minka, it would make sense if you're comfortable with it, reaching out to talk more offline because it sounds like
Yes,
there's a lot to talk about your individual situation. But
yes.
it does bring up something I'd love to flag for the whole group if that's possible. Something I haven't had a chance to talk about yet is like there are these anti-discrimination statutes that apply to tenants in housing. That's true for like the city, the state, and there's federal laws. It can vary based on the size of your building. So it is kind of like all things, right? It depends on people's certain circumstances. But there can be rights for tenants to get reasonable accommodations or even reasonable modifications to structures. It varies depending on, it's very fact specific. So again, I'd encourage us, if you're comfortable with it, to reach out so we could talk offline. But it is important for people here generally to know that you can have rights as someone who is disabled, and needs accommodations to enjoy your dwelling unit, to have the same equal access to your dwelling unit as other people who might not have disabilities. These are rights that are yours, to be defended and honored. So I think it'd be good to reach out to talk more, but it is important for everyone to know that they
Oh no,
can be entitled to
I
these
definitely
things.
will reach out. Yeah, I appreciate that.
No, thank you for your question, Minka. And please, yes, we look forward to receiving your email. I want to read Dina Myers. She works with landlords, shelter providers, real estate brokers to assist with clients in New York City housing vouchers and find affordable housing. Dina, please email me at info@buj.org and let's see if we can find ways that we can collaborate and help the community. And I love your statement of knowledge is power, know your worth, and add tax. And hopefully that this is what this programming is doing, so that you know your rights and then you are feeling confident to say, no, this is what I deserve and more. Um, and then she also informed that there's a new housing program called New York City Housing Access Voucher. It's a pilot program. We'll look into it and see if we can find out more information about that. Nancy, what if the landlord is in a foreclosure proceeding? Very good question. What are the tenant rights facing an eviction?
Yeah, this is a great question. So, one, I'll say, like everything, right? It depends. So I've been answering everything for what, because when you say when it's in a foreclosure proceeding, that doesn't necessarily mean the house has been foreclosed on, and that doesn't necessarily mean the house has yet been sold at public auction, public foreclosure auction, right? So there are many steps in a foreclosure proceeding, but I'm going to guess that you're talking about a case where the landlord has been foreclosed on and maybe the house has been sold at public auction. Your rights, tenants have rights, full stop. Your rights may vary depending on whether or not you have a lease or you don't have a lease, and whether or not you're a rent stabilized tenant or you're not a rent stabilized tenant. It can be the case that if you are someone who's had a lease, let's say in this hypothetical we're talking about, you have a lease, the house has been sold at auction, and now the new owner wants to come in, you have the right to finish out the term of your lease. Okay, and if you're rent stabilized, it's maybe still going to continue to be a rent stabilized unit. If you don't have a lease, like you are month to month or something, your amount of time in the unit can vary based on how long you've been there and how much notice you have. But again, in all these cases, I want to flag that you can't just have the locks changed, right? Eviction goes through the court system. So still, you would not just have your bags out on the street. It is a process that has to go through the court system, and your level of protection will vary, like I said, based on if you have a lease, if you've not had a lease, rent stabilized, not rent stabilized, and how long you've actually been in the unit. And also, again, like where in the foreclosure process you are to see whether or not those are triggered. So there are also, I'll just say this, I found that I believe it's the New York State Attorney General has a really good pamphlet on this. Maybe Kendra could send it to you to attach when you're sending out resources, that I often send to tenants because I think it's really spelled it all out.
Got it. Thank you. And I will definitely add that resource when we send out the information. Minka, I recommend to email us at info@buj.org and I'll be able to get your email over to Aldella and Molly. Uh, Anna. Oh, and now we are at 7:08. We're gonna go. We have one, two, three more questions, and then we will have to call it a night from there. Anna Crespo asks, can one apply to have the one-shot deal repayment reduced or forgiven if one has lost their job since receiving the one-shot deal?
Yeah, so I also see that the next question is from Anna Crespo as well. So I think I'm gonna combine comment on those two.
Very nice.
But like I had mentioned, recoupment itself is a little bit of a nuanced topic. Depending on what type of one-shot deal you get, or it's really a special grant request, right? If it's going through a cash assistance case or something like FEPS, right, the recoupment is never going to be a thing that occurs. It's not supposed to happen. On your award letter, it'll say this is non-recoupable funds, right? But if you're doing a one-shot deal, and your household without children, there's also other exceptions. So if you're on SSI or SSDI, you're really not supposed to face recoupment. That said, this question of reducing the recoupment payment amount based on your current income is 100% something that you can advocate with HRA. When recoupment is something that you're presented with and you can see that you can't afford it and it's going to jeopardize your current housing, you really should. You'll get a letter, and on the letter, there'll be contact information. If you get a one-shot deal and it's approved, you might not be asked to pay recoupment for a couple of years, maybe a year from then, or 2 years, 3 years, whatever it is. And based on whatever your situation is, you'll see at the end of the letter that there's a contact for payments, and you can reach out to them and let them know your current income, your current expenses, and anything else you may be facing that could prevent you from the repayment. And it is definitely something that you can negotiate. If that's something you're experiencing right now, I see that you said that you had the retaliation with your car, and I'm sorry that you experienced that. I have not heard of that happening to someone yet. Although I know that HRA does take into account assets when applying for things like a one-shot deal and grants and all of that. But it's something that, yeah, I implore you to talk about when recoupment comes up because it is a negotiable amount. Yeah.
Awesome. And she did inform us that she has Social Security. So
Yeah.
um, thank you for explaining how we can avoid recoupment with having Social Security. And then the final question, Mark Pierre asked, what happens when his landlord violated a stipulation signed by the court?
Yeah, so that is definitely a situation where I recommend reaching out for legal assistance or legal guidance to give you a more tailored answer. But I'm going to talk in like generalities, what you could do. If you have a stipulation signed by the court, you can go to housing court and file something called like an order to show cause, which is something to like get the court's attention at this issue. So like, for example, let's say like your landlord agreed, I'm going to conduct repairs and I'm not going to harass this person. And then they are harassing you and they didn't conduct the repairs on the day you did. You reached out to them, they're still not doing anything. You can take your stipulation, go to court and say, I want to file an order to show cause and bring it to the judge's attention that they have been violating the stipulation that they agreed to. When you do that, you can even bring proof with you to say, like, here's the proof that, like, here's our text, a snapshot of our text conversation where I said, are you around? You said you would come. You know, I'm sort of just like giving hypotheticals, right? But whatever you have, bring it to the court to bring it to the court's attention that this violation has happened, because a stipulation signed by the court has the same weight as a court order. So if a landlord is violating it, they are violating a court order and it should be brought to the court's attention. There might be more specifics to the issue you're talking about, you know, more nuance than I'm kind of can gleam on in this context. And I would encourage you to reach out for more advice.
Thank you, Molly. And I know I said three questions, but there's a really good one in our Q&A box, and especially with this snow event. Is failure to shovel snow a violation of warrant of habitability?
That's a good question that I have not yet considered. I would offer that like landlords are in charge of like common areas and common spaces, and they're meant to like keep those, like for example, like your entrance door, the lobby, those are the domain of the landlord. So to the extent that like, you know, like your like maybe steps up to the home, or I think it would like kind of depend, right? Like what we're talking about here, whether it would rise to that level. But I do think that like if you're concerned for safety or something, like you can't get home or there's tons of ice everywhere, you've tried to contact the landlord, that might be a situation where even if it doesn't violate the warranty of habitability, meaning it doesn't violate a term of your lease, it might violate a city code still. And you might want to get 311 involved if you're worried about your safety, because there is like tons of ice or you're unable to access something because of the snow that you're talking about. I hope that's helpful.
Yeah. And We have one question left, and I think that'd be all of them. And it's a really good one. Ace wants to know that this seems to be geared towards tenants and buildings, but he's in a private home, and the landlord died last year, and he's being asked to leave by the children. Um, he's been looking for a place, but has no luck. Does he have to leave?
Um, okay, I do think that maybe we could reach out for more, tailored advice on this one. But, things that I'm saying that might be relevant, right? Are you on a lease? Are you month to month? Is this a question? Is this a court action when you say you're being asked to leave? All of that might impact, what we're talking about. But those are things that you want to think about. And I am sorry that's happening to you, by the way. It sounds like that's very difficult and that is a very stressful situation. So I do recommend reaching out and maybe we can provide some more tailored advice because I have a couple follow-up questions.
Yes, please, Ace, reach out and thank you all so much for staying the additional time to answer the questions and all my last one questions. I appreciate it. Please reach out to us if you do want more follow-up at www.info.bu. I'm sorry, the email is info@buj.org. I will be emailing you from that email address with the link to this recording, all of the links that we talked about. Also do want you to know that it's also tax season. If you received any notices, you have any tax issues, please feel free to drop in at our drop-in tax table every other Thursday. It is a free individualized 15-minute appointments with a tax specialist and one of our tax attorneys to talk about your tax situation. We also have a three-part tax series happening right now. Next week is the last part of the three-part series, but I would recommend joining. If you have any specific questions you want to ask, we do have a representative from the IRS that joins us on those calls. And you'll be able to get your questions answered live. And then with that, I just want to thank Al, Molly, Tiffany, um, I want to thank Fernando and Assembly Member Hooks and Antonia for staying around for our language translation. Thank you all for your commitment to the community and all the work that you do day in and day out. It is truly invaluable. And I look forward to continuing to work with you and bring more information to the community. And if anyone ever has any questions, feel free to reach me at info@buj.org. And does anyone have any last words on the panel?
No, thank you everyone for joining us again. Yeah, spending your Wednesday night with us and listening to us. Thank you everyone and for your questions.
Yes, thank you. Hey, be safe and have a great evening.
Yeah, I just want to say thank you, everyone. Really, truly. Thank you, Kendra. Thank you, Al. Thank you, Molly. Thank you to Assemblymember Hooks for having us. Great night, everyone.